President. I rise today with my colleagues to make very, very clear, not just to our Republican colleagues, but to history, of exactly what's at stake. Let there be no doubt that Senate Republicans are threatening to go nuclear on Senate procedure to gut California's Clean Air Act waivers. But this isn't just about California's climate policies, and this isn't just about the scope of the Congressional Review Act, and this isn't just about eliminating the legislative filibuster. No, what Republicans are proposing to do would go far beyond just eliminating the filibuster. If they insist on plowing forward, federal agencies will now have unilateral power to trigger privilege on the Senate floor with no institutional check from the legislative branch. Just as EPA has submitted California's waivers with full knowledge that they are not actually rules, other agencies will now be free to submit any type of action going back to 1996. Think licenses, permits, leases, loan agreements, drug approvals. There would be no limit. Now, we've been safe from this kind of abuse until now because the Senate has a process in place for the Government Accountability Office to help the Senate parliamentarian determine privilege for the purposes of the CRA. But Republicans are now threatening to throw that process out. And the consequences of throwing the rule book out the window will be very, very serious, Mr. President, but it's not too late to turn back. Republicans must understand exactly what they're doing. So today, I think it's important to establish some facts about the process that protects the Senate from agencies that try to game the system. Mr. President, I have a parliamentary inquiry.
The senator will state his inquiry.
Mr. President, is it correct that the then Senate parliamentarian in 2008, in coordination with bipartisan Senate leadership and committee staff, developed a Senate procedure for determining what qualifies for expedited consideration under the Congressional Review Act when an agency fails to submit an action to Congress, and that a precedent under that procedure was first established in 2012?
Based on information that is publicly available, yes, that is correct.
Thank you. And is it correct that that procedure, which uses a GAO determination as to the nature of the agency action, whether or not it is a rule, has been implemented numerous times by senators on both sides of the aisle, including one occasion where a GAO letter gave rise to a joint resolution of disapproval, which became law?
Based on information that is publicly available, yes, that is correct.
Thank you, Mr. President. I yield the floor.
President.
The senator from Rhode Island.
Mr. President, I joined the ranking member of the Rules Committee with a parliamentary inquiry of my own.
The senator will state his inquiry.
Is it true that unless a piece of legislation is privileged under a rule or statutory provision or is the subject of a unanimous consent agreement, motions to proceed to that legislation are generally fully debatable?
Yes, that is correct.
That is correct. And for those of you following this at home, fully debatable means 60 votes are required to end debate, which Republicans do not have. Mr. President, I have a further parliamentary inquiry.
The senator will state his inquiry.
Is it commonplace for Senate offices and for whichever senator is presiding over the Senate to consult with the parliamentarian to determine whether and in what manner expedited procedures apply under a host of statutes, including the War Powers Act, the National Emergencies Act, the Congressional Budget Act, and the Congressional Review Act.
Yes, that is correct.
Again, for those of you following this at home, means that this is the commonplace way in which the Senate operates, and when it becomes the parliamentarians' call on a matter and not anyone else's call. So in the Congressional Review Act matter before us, here's what happened. Both sides drafted written memoranda to the parliamentarian. Both sides presented oral arguments to the parliamentarian. The parliamentarian asked questions of both sides, and the parliamentarian, our neutral referee, reached a decision. That all took place here in the Senate, actually over there in the LBJ room. The GAO was not even in the room when the arguments were made. And that decision, the decision of the parliamentarian, is what is now at hand in what is about to happen here in the Senate. And with that, let me note the presence on the floor of the Democratic leader and yield the floor.
Mr. President.
The Democratic leader.
Mr. President, is it true that the parliamentarian advised leadership offices that the joint resolutions of disapproval regarding the California waivers at issue does not qualify for expedited consideration under the Congressional Review Act?
While the chair has no personal knowledge of those circumstances, the parliamentarian has advised me that such advice was given.
Thank you, Mr. President. Before I yield, I want everyone to understand what the essence of my question was. This week, the Republicans want to use a legislative tool known as the CRA in an unprecedented way to repeal emissions waivers that the fossil fuel industry has long detested. The CRA has never been used to go after emission waivers like the ones in question today. The waiver is so important to the health of our country, and particularly to our children. To go nuclear on something as significant as this and to do the bidding of the fossil fuel industry is outrageous. And we just heard, in response to my inquiry just now, that the parliamentarian affirmed this, that these California waivers are not eligible for the expedited procedures that the CRA affords. That means that legislation to repeal these waivers should be subject to a 60-vote threshold in the Senate. To use the CRA in a way that Republicans propose is going nuclear. No ands, ifs, or buts. I yield the floor.
The senator from California.
Mr. President, I wonder if any other member of this chamber grew up like I did, where on a pretty regular basis, we would be sent home from grade school because of the intensity and dangers of smog that settled over the San Fernando Valley, the city of Los Angeles. How many of you grew up to more reports of unhealthy air quality in the air quality index or hazardous air quality forecast for that particular day than it was just clean air? But that's the case for far too many Californians still to this day. But it's the reason why decades ago, Congress recognized both California's unique air quality challenges and its technical ingenuity and granted California special authority to do something about it. And thanks to the bipartisan Clean Air Act of over 50 years ago, California has had that legal authority to set its own emission standards, to petition and be granted waivers to be able to show leadership for over 50 years. because Congress recognized, rightfully so, that air quality in West Virginia or Wyoming is different than it is in Southern California, that there's fewer cars on the road in Salt Lake City than there are in Los Angeles, and because California was and still is the center of innovation in the United States. Yet in 2025, it appears that Republicans want to overturn half a century of precedent in order to undermine California's ability to protect the health of our residents. By using the Congressional Review Act to revoke California's waivers that allow us to set our own vehicle emission standards, Republicans seem to be putting the wealth of the big oil industry over the health of our constituents. What happened? Nearly 60 years ago, it was Republican Governor Ronald Reagan who established the State Air Resources Board in California. 3 years later, it was Republican President Richard Nixon that signed into law amendments to the Clean Air Act, fulfilling a promise that he made during that year's State of the Union, that clean air should be, quote, the birthright of every American. I wonder if Governor, future President Reagan, President Nixon would recognize their own party today. I also want to take a moment to speak to parents of young children, not just in California, but across the country, because parents are rightfully concerned about the safety of what our children eat, what medications they take. As parents, we have some level of control over certain things, like the food we give our kids or the medications that we provide. But some things that we can't control as parents include the quality of the air that they breathe outside. We can't individually control the toxic nitrogen oxides, the carbon monoxide, the sulfur dioxide, the benzene and particulate matter that flood into our air and into our children's lungs. Now, unless industry were to somehow decide to suddenly just do the right thing, it's incumbent upon government to act. And that's what California has done. But of course, this discussion debate is more than just about public health. California's emission standards also represent ambitious but achievable steps to cut carbon emissions and fight the climate crisis. We've taken a stand because we know transportation is the single largest contributor to greenhouse gas emissions. And California has been proud to set the example for other states who may choose to follow suit. Now, Mr. President, I use the word choose, and I'll use it repeatedly because over and over again in this debate, I've heard some arguments coming from Republicans that I think are misleading the American public. I hear arguments like, well, California, quote, isn't simply setting a stricter standard for itself, it's setting a new national standard, end quote. Or California's, quote, emission standards would become de facto national ones, end quote. So I want to be clear, California has not and cannot force our emission standards on any other state in the nation. As much as I may love that authority, that does not exist. But yes, over a dozen other states have voluntarily followed in California's footsteps, not because they were forced to, but because they chose to in order to protect their constituents, their residents, and protect our planet. And the truth is, they do have a tremendous blueprint to follow. California is now the fourth largest economy in the world and the largest contributor to the federal treasury. California didn't get there by sticking our head in the sand as the clean energy transition blossomed elsewhere. We leaned in and we proved that what's good for the air is good for business. What's good for the planet and public health is good for the economy. But meanwhile, the cost of inaction continued to hit Americans where it hurts the most, in our wallets. In 2021, the Natural Resources Defense Council estimated that air pollution from fossil fuels costs Americans an average of $2,500 a year in medical bills, or over $820 billion in total. So no, this isn't just about Republicans defending against some California power grab or fighting on behalf of the little guy. Which brings me to my final point. Because it's not just why Republicans are trying to undermine California's climate leadership, it's how they're trying to do it. Now, I've been very clear on where I stand on the filibuster. There's been a quiet counter-argument in several conversations here amongst colleagues. Yes, I do support lowering the threshold to pass a bill from a supermajority to a simple majority, but only after there has been an opportunity for amendments and debate in an effort to stop the endless partisan gridlock that prevents so much more progress that the American people deserve. I voted to make that rule change and codify it in the Senate rules. But in 2022, when we did so, Republicans opposed it, and they defended the filibuster and the 60-vote threshold as sacred. Today, as the ranking member of the Senate Rules Committee, I want to make sure everyone understands exactly what Republicans are trying to do here, now. The Clean Air Act passed this body under regular order by a vote of 88 to 12 in 1967. The landmark Clean Air Act amendments passed the Senate 89 to 11 in 1990, overwhelming bipartisan support. But now, Republicans are trying to pass these bills that strike at the heart of the Clean Air Act's provision for California on a simple majority 50-vote threshold, bypassing the filibuster. Republicans certainly must know that they don't have the votes to amend the Clean Air Act under regular order. If they did, they'd choose that path. They also know that Congress doesn't have the authority to amend the Clean Air Act through the Congressional Review Act. Don't just take my word for it. They heard it from the independent, nonpartisan Government Accountability Office. Not just once, but twice. And they heard it from the Senate parliamentarian who told them they could not move forward. So what Republicans are now trying to do is truly unprecedented. And it's about far more than simply California's clean energy policies. Republicans are threatening to vote on whether or not to overrule the Senate parliamentarian. Republicans are effectively saying that whenever the parliamentarian rules against them, they can simply disregard her to bypass the filibuster and pass legislation on a simple majority vote. So no, this isn't some one-off change to the rules. This is throwing out the rule book entirely. Because if they can ignore the parliamentarian here, then why not on an upcoming tax bill or on their efforts to gut health care for many Americans, or whatever the latest overreach is called for by President Trump. This goes way beyond the filibuster. The Trump administration could send an endless stream of non-rule actions to Congress, going back to 1996, including vaccine approvals, broadcast licenses, merger approvals, and any number of government decisions that apply to President Trump's long list of enemies. All it would take is a minority of 30 senators to introduce related bills, and the Senate would be bogged down voting on agency grocery lists all day long. Is that how we want to spend our days here in the Senate? Voting on every vaccine approval because Secretary Kennedy decides to send them to Congress? So to my Republican colleagues, I should also say this. The old adage says, what goes around comes around. And it won't be long before Democrats are once again in the driver's seat here, in the majority once again. And when that happens, all bets would be off because of the precedent you could be setting here at this moment. Think mining permits. Think fossil fuel project approvals. Think LNG export licenses or offshore leases, IRS tax policies, foreign policy, every Project 2025 or DOGE disruption, every agency action that Democrats don't like, whether it's a rule or not, and no matter how much time has passed, would be fair game if Republicans set this new precedent. So I suggest that we all think long and hard and very carefully about this. And I would urge my colleagues, all my colleagues, to join me not just in defending California's right to protect the health of our residents, not just in combating the existential threat of climate change, but in maintaining order in this chamber. Thank you, Mr. President. I yield the floor.
Mr. President.
The senator from Rhode Island.
Mr. President, let me start with just a quick overview of the Congressional Review Act, which brings us here to the floor today. Under the American legal system, administrative agencies can make rules, and there's a very robust process for doing so. The agency often gives a notice of proposed rulemaking so the world will know what they're considering doing, and then solicit comment from affected stakeholders, the public, a wide variety of people. So you start with an agency that seeks to make a rule. They have to follow the processes of the Administrative Procedures Act, which is a very careful statute, well policed by the courts, with a very robust precedent around that. And at the end of the day, the agency creates a rule, and they adopt the rule. Now, you could always appeal that rule to a court. But what Congress decided many years ago was that in that situation, where an agency had gone through the APA process and had promulgated a rule, that there would also be a congressional review of that rule, not just the court. And the filing of the rule here in Congress triggers a period of review in which senators or members of the House can call up the Congressional Review Act and seek to disapprove the rule. So this whole thing was originally designed, and for all the decades since the Congressional Review Act was first passed, has always been to address agency rulemaking under the Administrative Procedures Act. Well, the fossil fuel industry pretty much runs the Republican Party here in Washington, and for a long time it has objected to California having clean air standards that many states, including my state, voluntarily follow because it's good for the health of our people to have clean air. It's good to have less smokestack emissions, less exhaust emissions, but means less gas sales for the fossil fuel industry. Efficient cars may mean lower costs for consumers, but those lower costs for consumers are lower sales for the fossil fuel industry. So the majority here has decided to jump outside that tradition, that it takes a rule developed by an agency to kick off the Congressional Review Act. In this case, again, for decades, pursuant to a statute, California has had the right to set emissions standards. And it was never done by rule. It was always done by an executive action, in this case called a waiver. And what's now being done is a real violence to that distinct and clear process. This breaks the Congressional Review Act in at least 3 ways. First, it breaks the time limits of the Congressional Review Act. Again, in the ordinary course, the rulemaking goes through its ordinary process under the APA. And when it's done, it then comes here to the Senate, and we've got a short period of time in which to make a determination whether to try to disapprove it or not. Under the rule that is, under the proposal that is threatened here, you'll be able to take any executive decision in decades. And simply by dropping it into the Federal Register, making that submission and sending it to Congress, let the majority party say, okay, we're going to overrule that. Not a rulemaking, nothing done under the Administrative Procedures Act, just an executive decision. So the window back in time outside of the ordinary 60 days is the first thing that they broke. The second thing that they break is that it has to be a rule. Like I said, pretty much any executive action could be plowed through the process that is being created here. And so, however settled the reliance on a particular permit or a particular license or a particular executive decision from years ago, it's all up for grabs under this. And the third, of course, other than breaking open the time horizon of the Congressional Review Act and breaking open the subject matter horizon of the Congressional Review Act, is to clear out the police of the Congressional Review Act. And that is the parliamentarian who made what in my view was not a difficult decision to say, this is not a rule, never was a rule. Year after year, administration after administration, Congress after Congress, California has used this waiver and it was never a rule. And now, the parliamentarians' plain, clear, obvious decision that this was not and is not and never was a rule is what they're planning to overturn. So you're breaking open the time horizon, you're breaking open the subject matter boundary, and you're knocking out the neutral police officer who's supposed to keep us living by the rules. This does not end well. By the way, I've heard it said that the argument from the other side is going to be they're not overruling the parliamentarian, they're overruling the Government Accountability Office. Well, if that's what they wanted to do, there are ways to do that. If the Government Accountability Office says that the law says a certain thing and we disagree, we can go back and change that law. We can amend it so that it's clear what it is that we want the law to say and correct the GAO decision that way. We could pass a joint resolution that does the same thing. We could even pass a simple Senate resolution, but guess what? All of those things are fully debatable. And as I said earlier, fully debatable means what? They mean 60 votes to end debate, meaning that the minority party gets a vote, gets consideration. They don't want that. They want to ram this thing through for their fossil fuel donors, period, end of story. Don't care what they break. But please, don't pretend that you're overruling GAO. My team, along with Senator Padilla's team, was in the LBJ room making those arguments to the parliamentarian. There was robust debate. We filed briefs. Questions were asked. The whole thing was a very vigorous contest. And she ruled. And she ruled. And GAO was not even in the room. That stage was long since past. The reason we're here is to overrule the parliamentarian. The reason for overruling the parliamentarian is to get a simple majority to get around this. There are other ways this could have been done too. EPA didn't have to do it this way. EPA could have gone through the Administrative Procedures Act and done a proper rulemaking. We could have amended the Clean Air Act and had a proper debate about this on the Senate floor. EPA would have followed regular Administrative Procedures Act order. The debate about the Clean Air Act would have followed regular Senate order. But no. Or the fossil fuel industry could have gone to California and said, hey, things have changed a little bit. We'd like to figure out a way to work with you. You change your rule. They're the real principal party here. Rhode Island follows the California standard. They could have gone and negotiated with the sovereign state of California instead of coming here to just roll the state using a sneaky parliamentary maneuver and choosing to go neutral to do that. So this is not a great day in the history of the Senate. We are opening up a Pandora's box of multiple abuses. And let me just point out that there actually are a lot of legitimate CRA, Congressional Review Act targets out there. Many dozens of decisions that have been made in this Congress that lend themselves to a proper use of the Congressional Review Act. And guess what? It takes 30 signatures to bring one of those up. The minority can do that. So if the majority wants to start playing CRA games, well, even under existing CRAs where we don't need a 51 vote majority, we can start bringing up CRAs of our own, expedite them to the floor, have vote after vote after vote after vote after vote. There are ways in which we can respond. I intend to work with my leadership to make sure what the best way is, but don't think that this nuclear option gets deployed here, gets deployed for the fossil fuel industry, gets deployed against a sovereign state, and gets deployed to make air dirtier and water dirtier, and we just walk away as if nothing happened. That is not what will follow. I yield the floor.
Mr. President.
Senator from California.
Mr. President, here we are, the moment that we have been warning about, the moment the majority and its members used to say under their leadership would never come. And yet here we are, the week our colleagues may push to go nuclear and override the parliamentarian, killing the filibuster and going against their word to unwind 60 years of precedent and policy. And no matter what anyone says, that is what is happening. Our colleagues will be overturning the parliamentarian to end California's right to cleaner air. The majority promised, and I quote, "We can't go there." I'm old enough to remember just when it was they said it, because it was their majority leader just 19 weeks ago. 19 weeks ago. But not to worry, the majority says this is not what this is about, they claim. Instead, we have heard the majority try to dress this up as an attack on the nonpartisan Government Accountability Office, saying that their unprecedented action was preceded, almost warranted, by the GAO's actions. Yes, my colleagues, Senator Whitehouse, Senator Padilla, and myself, went to the GAO to ask for their guidance on whether this expedited mechanism called the CRA could be used to target California's waiver, California's right to establish stronger clean air standards. And yes, the GAO responded, affirming that this expedited process, this CRA, does not apply, that these are the rules, that if they want to strike down California's clean air rules, they can do so, but not in this summary fashion, not without 60 votes. That is the ruling that the parliamentarian has reaffirmed and which the majority now wants to strike down. But let's be clear, going to the GAO was nothing out of the ordinary. In fact, it was exactly what both parties have done when adjudicating this issue for decades. There are senators serving in this chamber, Republicans and Democrats, who have made use of the exact same process by going to the GAO. There have been more than 20 different opinions delivered by the GAO at the request of Republican senators and members of Congress in the last 3 decades, more than 20 times. And in the cases where the GAO found that the CRA may not apply, this expedited process may not apply, that decision has stood. They did not move forward and respected the rulings of the GAO and the parliamentarian until now. So what does all of this mean? What it means is California has established clean air standards. It was given a waiver under the Clean Air Act to do so. It has done so for decades. Those standards have been adopted voluntarily by other states. And as a result, in California and many other states, we have cleaner air to breathe. Until now. Until now, when the majority has decided to abolish the filibuster so that they could eradicate California's clean air standards, so that they could use a summary process that doesn't apply here to get over the hurdle that they require 60 votes in order to do this. And I urge my colleagues and the American people not to be distracted by suggestions that nothing is going on here, nothing new is going on here, no precedent is being set here, because it is. And that is to eliminate the filibuster in the service of the oil industry. In the service of the oil industry. Whether it's an attack on the GAO or the parliamentarian, the new ground we find ourselves in today is dangerous both in the effects it will have on California and on this body. In California in particular, because it means that this Congress is abolishing the filibuster so that Californians will have to breathe dirtier air. That's what this is about. They want to abolish the filibuster so that polluters can pollute more and Californians have to breathe dirtier air because they know they don't have the votes for it otherwise. And taken together, my colleagues are embarking on a path that will forever change the Senate. It will not just mean dirtier air for California and dirtier air for all the other states that have adopted California's higher standard. It will also mean that the filibuster is gone for a whole range of things. Now, I represent a state that makes up 1 out of every 10 Americans. It is the 4th largest economy in the world. So 1 out of every 10 Americans is going to be deeply impacted. And of course, if you add all of the other states that have adopted this higher standard for their citizens, it may be more like 1 out of every 5. But it's more than that as well. Because what we have at stake is also a state's ability, its right to make its own laws and to protect its own citizens without having this body overturn that right. This week's vote is short-sighted because it's going to have devastating impacts for our nation's health, but it's more than that. And it should send a chill down the spine of legislators in every state and communities across the country, regardless of their political affiliation, because the Senate is now setting a new standard and one that will haunt us in the future. And it will haunt those states whose senators vote to go down this path. Make no mistake, today it's California and our ability to set our own air quality standards. But tomorrow, it can be your own state's priorities made into a target by this vote to open the Pandora's box of the Congressional Review Act. That oil drilling lease that one of your states got approved, that can be on the chopping block with a simple majority now if the filibuster is eliminated. That license for a new energy hub, gone with a simple vote of this body. That new community grant, gone with a simple vote of this body. That's fair game now if the majority adopts this tact. This vote to expand the power of this expedited process called the Congressional Review Act will be used to target Democratic and Republican priorities alike. I moved to Los Angeles in 1985. I remember what it was like to breathe the air in Los Angeles in the 1980s. I have seen images of what the air was like in Los Angeles in the 70s and the 60s and the 50s. We are a basin. And with all of that automobile traffic and all that congestion and our geography and topography, it means that exhaust gets trapped, that smog gets trapped. There are times when you can't see the hills in front of you. There are times when you can't see down the street, at least there used to be. There's a reason why California got this waiver decades ago, because there were unique challenges facing places like Los Angeles. And so California acted to protect its own citizens. But if your state acts to protect your citizens, whether it's from dirty air that can give you lung cancer, or whether it's pollutants in the water that can give you all other kinds of cancer, do we really want this body on a simple majority vote to be able to eviscerate what the states are doing to protect their own citizens? So I urge my colleagues again not to abandon states' rights in the Senate this week, because this may be a policy that you agree with today, but the thing is about a slippery slope. You can be the one who starts down the slope, but you don't get to be the one who decides where it stops. I yield back.